Running a business can be a complicated endeavor. Whether your company is an S-Corp, C-Corp, or an LLC, it's very important to lay out the groundwork for its internal operation and make sure all of the stakeholders are on the same page from the get-go. Corporate bylaws and operating agreements help companies do exactly that. Let's start with corporate bylaws. What exactly are they? When a company is legally incorporated, this is one of the first documents approved by the board of directors. Think of it like an internal manual. Bylaws describe the standards of operations for your company and determine important terms regarding board and shareholder meetings, voting rights, responsibilities, quorum, and more. You may ask, is establishing bylaws required for all corporations? Well, that depends on what state you live in. Currently, 31 states legally require corporate bylaws, while more than a dozen states don't. You can check out the link below to see a complete list of the states. Regardless, it may be helpful to have a legal document like the bylaws that keep the board of directors and officers in agreement and the company running smoothly. No two sets of bylaws are likely to be exactly the same because every company is different, but they generally cover many of the same provisions, including the company's official name and statement of purpose, board of directors and quorum, meaning how many directors must be present in order to make decisions on behalf of the company, company officers, their roles, and how they will be elected or appointed, shareholders, stock certificates, and dividends, indemnification, which may protect the company's board of directors and officers against losses or damages in connection with the company, and finally, an amendment procedure for making changes to the bylaws in the future because it will likely be needed as your company morphs and grows. Now, let's take a look at corporate bylaws counterpart for LLCs, the operating agreement. Operating agreements serve as key internal documents for LLCs by outlining the functional and financial standards that will govern the ins and outs of the business. When the operating agreement is signed by the company's owners, also known as the members, it acts as an official contract binding them to the rules. Similar to bylaws, an operating agreement can be kept as a confidential document. While it's legally required in only 5 states, it is highly recommended that LLCs draft an operating agreement anyway. Without it, businesses have to abide by the default terms of whatever state they are operating in, which may be general in nature and not very applicable to your own company. As a legally binding document, operating agreements typically contain many important provisions that detail the unique logistics of your company. Some helpful things to include in an operating agreement are percentage of members' ownership, voting rights and responsibilities, powers and duties of members and managers, distribution of profits and losses, meeting procedures, rules for buyouts and buy-sells, and lastly, procedure for making amendments to the operating agreement in the future. We're eForms, the largest online database of form-fillable legal forms, and we have just about every document you can imagine for corporate bylaws, operating agreements, and more. Click the link to access templates that can guide you right through the process.